Hey, I want to give my thoughts regarding the FTX case, the class action complaint against Kevin Paffrath or Meet Kevin, Graham Stephan, Andre Jeek, Jaspreet Singh, Brian Jung, Jeremy Lefebvre, Tom Nash, Ben Armstrong, Erica Kohlberg, and Creators Agency. And ironically, it's in the district where I live. I'm not a lawyer, but I have a lot of experience litigating cases. In fact, it's the same court where I filed a complaint against Option Alpha, and I believe that this was primarily a Lanham Act. But back to the FTX case. So I went through the entire complaint, and in general, we call this a quote-unquote shotgun complaint, where it's just very, very generic. The issue, starting from a very high level, is that about 70 to 80% of this complaint is just dealing with what happened and what transpired with FTX. But the issue is that in court, the complaint is the master document. It lays out all the factual arguments, the causes of action, the prayers for relief, etc. But with this complaint, it goes into significant depth into what actually transpired with FTX, but FTX isn't named as a defendant in this class action lawsuit. And one of the major problems with this complaint is that it doesn't necessarily ascribe or attribute specific claims and damages or causes of action to the individual defendants. And because of that, it makes this complaint very ripe and very susceptible to a 12b6 motion, which is a motion to dismiss. Because, for example, let's look at it. I'm going to search for Kohlberg, right? So one of the defendants, Erica Kohlberg, searching for her name, she's listed once in the header, and she's listed once more as essentially a definition, whereas defendant Kohlberg is, upon information and belief, a founder of Defendant Creators Agency, LLC, and is currently identified on Creative Agency's website as one of the finance business creators with 18 million social media followers. She's never mentioned again. So basically, you can name anyone you want as a defendant. You can put Elon Musk as a defendant, and then you can list him out and say, defendant Elon Musk is, upon information and belief, a founder of PayPal and Tesla, and is currently identified on Tesla's website, etc. The issue is that there's no cause of action that is going to link Erica Kohlberg or Ben Armstrong or Tom Nash to the specific damages. And because of that, there is no cause of action, and there's no causative reason for this complaint to not get dismissed. In many respects, I feel like the attorneys for the plaintiffs have filed this case just because they know that it's going to lead to free advertising, and perhaps they feel that potentially it can lead to increased business in the future. But this complaint, in my opinion, is really trash. There's no cause of action. And what I think is going to happen is defendants are going to file a 12b6 motion. They might end up invoking the anti-SLAPP provision. The issue with the anti-SLAPP in Florida is that there is a fee reversal provision. In the event that the anti-SLAPP provision isn't actually granted, then it is possible for the plaintiff's attorneys to then petition the court and request that defendants compensate them for the legal fees for their specific motion. But in all likelihood, what would happen is that the defendants would file a 12b6 motion to dismiss, and then plaintiffs would immediately file an amended complaint, and therefore the motion to dismiss would be moot. And then defendants will wait for an updated or an amended complaint, which would hopefully be more specific, and then in which case defendants would then file a new 12b6 motion. And usually what happens with a 12b6 motion is that parts of it are granted and parts of it are not. So then the judge will probably come back and say that the complaint has to be significantly more specific as to the actual damages that the plaintiff and that the complainant are alleging. Now, another thing that makes me believe that this complaint was put together without much thought is if you look at the summons, these people don't live in these addresses. You know, if you look at like Erica Kohlberg, she definitely doesn't live in Stuytown, which this address is. I mean, Stuytown is like a 100-year-old building like Peter Cooper Village in Stuyvesant Town. If she lives in apartment 5H in Stuytown, then I would be very, very shocked. The only one that I feel extremely confident is right is Graham Stephan. And because of that, I'm going to block out the address, because even though this is public information, at the same time, I don't want everyone who's watching this video to have his home address. So Graham's address is correct. I looked up Jeremy's address. He definitely doesn't live there. I think he lives in Las Vegas. This address for Kevin Paffrath is also not correct. They said in the complaint that Tom Nash lives in Australia, which is not true. Yeah, Tom Nash, a YouTube star with over 283,000 subscribers, and he's a resident of Sydney, Australia. It's my understanding that he lives in the United States. I just feel that this complaint really doesn't deserve that much attention, because the attorneys definitely didn't put that much attention into creating this complaint. So let's say I was named as a defendant. I would really not stress out at all. When filing the complaint, all the defendants have to be served within 90 days in order for the court to have jurisdiction over them. And considering that there's about 10 defendants, I actually think that a great strategy for some of the defendants is just to evade service. Because clearly, in my opinion, the attorneys for the plaintiff seem to be very negligent. This complaint is horrible. The summons don't have accurate addresses. And by putting an inaccurate address, that's going to use up time, because the summons are going to get issued, and then they're going to attempt service at these incorrect addresses. And then plaintiffs are going to have to go back, find the updated addresses, and then request updated summons with the correct addresses, and actually effectuate service, and then file affidavits of service in order to ensure that the court actually has jurisdiction over the defendants in this case. So considering how, in my opinion, the attorneys for the plaintiffs have been so negligent in putting together this complaint, if I were one of the defendants here, I would completely evade service and not answer the door. And in my opinion, I believe that they wouldn't be able to serve me for 90 days. Now, that being said though, some of these people have already made public statements regarding the lawsuit. So the fact that they're actually aware of it, that might actually negate their ability to evade service and then claim that the court doesn't have jurisdiction over them. And so I know that BitBoy crypto guy has made public comments about it. I know that Kevin Paffrath and Meet Kevin have made comments about the case. So I think that might complicate their situation. But in general, if I was a defendant here, I definitely would not be concerned about this case. Now again, plaintiffs are obviously going to file an amended complaint here, because there's no way that even if defendants didn't challenge this complaint, that this complaint would actually hold up in court. The judge would look at this and say, hey, there's no cause of action, so there's no way for me to rule on this. It would end up getting dismissed in summary judgment. A few other thoughts. If plaintiffs' attorneys are really good, I would immediately start sending out subpoenas and requests for depositions, and I would hit them pretty hard with discovery once the court has jurisdiction over them and once the defendants have been served. They can send out requests for production of documents, they can send out interrogatories, and they can send out admissions. And what they can do is they can essentially play the defendants off one another, because all of them, except perhaps for BitBoy Crypto, since they've accepted money from FTX, they can essentially gather discovery documents from the individuals and then use the discovery documents from some of the individuals against the others if they believe that some of the other defendants are not producing documents. So for example, if one of the defendants is very forthcoming in producing documents and then another defendant isn't, then the plaintiffs can then file a motion to compel and request sanctions against the defendant who is dragging their feet and not producing the discovery documents. So discovery is definitely a way for the plaintiffs to do a significant amount of damage in this case, but they just have to make sure that they're extremely aggressive in requesting documents and issuing subpoenas. And I bet you that the defendants are going to object to the subpoenas. However, in federal court, it's a lot harder to stop the discovery process than it is in state court. In state court, they have to file a notice of objection, and then it has to go to a hearing in order for the judge to rule on it. But in federal court, it is significantly harder to stop discovery. So I think that that's definitely an advantage for the plaintiffs as long as their attorneys are very aggressive. I am also very curious to see how the defendant's attorneys do, especially those who were hired under media insurance. I know that many people have said that media insurance is going to help out and that it's going to protect creators from frivolous lawsuits and from defamation claims and things of that nature. But I completely disagree. I think that when it comes to insurance, it is usually in the insurance company's best interest to minimize their claims and to minimize their payouts. So I don't think that the lawyers that are going to be hired for the defendants who have media insurance are going to perform that well, because they are going to be ordered by the insurance companies to reduce costs and to spend as little money as possible. Now, I can be completely wrong about that. These are just my thoughts. I'm sure that some lawyers that are going to be hired through media insurance are going to be significantly better than others. But I also feel that when you're using media insurance, you're basically taking the control away from yourself and putting it in the hands of an entity, which is the insurance company, that doesn't have your best interests at heart. The insurance company is going to be motivated to reduce payouts and to minimize their expenditures in this lawsuit. Whereas with the defendants, they want to make sure that they get the absolute best representation as possible. That's going to be an issue for the defendants who are using some of these insurance-appointed attorneys, because these attorneys might end up cutting corners and not objecting to some of the discovery requests or not filing responses to the motion to compel and things of that nature. And I think that that might be a major issue in this case. A few other things that I noticed when I read through the complaint: on page 5, number 13, it said Plaintiff Garrison did so after being exposed to some or all of defendants' misrepresentations and omissions regarding the FTX platform. As detailed in this complaint, executed trades on the FTX platform in reliance on those misrepresentations and omissions. As a result, Plaintiff Garrison has sustained damages for which defendants are liable. I mean, this is definitely a stretch, because the defendants are not agents of FTX. They don't have inside information. So for the complaint to claim intentionally misrepresented and omitted valuable information, that's just not something that the plaintiffs are going to be able to prove in this case. This case is going to be extremely expensive for the plaintiffs, and the lawyers are going to bill a ton of hours. I'm not sure how much money Plaintiff Edwin Garrison is paying them, or maybe these attorneys are just doing it on a contingency basis or for marketing purposes. But to have 10 defendants and to have to do discovery, subpoenas, depositions, and motions and response motions and answers and all the necessary work for a class action case for 10 defendants, that's going to be a multi-million-dollar lawsuit in legal fees. And just the procedural costs regarding filing documents and serving the defendants and things of that nature, that is also going to be probably around $10,000 to $15,000. So this is an extremely expensive case. Another thing that I wrote is the case is weak because it's hard to ascribe legal liability to influencers, especially influencers who likely have disclaimers indicating that the videos are for entertainment purposes only. For example, Jim Cramer doesn't have a good track record with Mad Money, but that doesn't mean that he'd lose a lawsuit. If an investor reads SeekingAlpha.com and an author provides a bad take, that author isn't liable to the reader. I'm conflicted here because I believe it's important for Americans to protect their constitutional rights. This case can be viewed as a prosecution of free speech. But again, while I don't think plaintiffs will win legally, there is definitely a way for them to win overall. Aggressive discovery, win the motion to dismiss hearing, etc. Similar to Erica Kohlberg, the complaint is deficient in that it's not specific. It lists defendants, but needs to explicitly say why they're included. For example, Brian Jung is listed as a defendant and listed once more at 26. But there are no explicit statements ascribed to him. To me, that's the biggest reason why this complaint may get dismissed unless it's amended. There's way too much information about FTX, its history, etc., and way too little about how specifically the defendants are liable. One of my friends is currently involved in litigation, and he filed a motion to dismiss. And in the specific ruling, the judge indicates a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The factual content that the defendant is liable for the misconduct alleged. Keep this in mind when reviewing the class action complaint. In that complaint, there's basically no meat on the bones. The complaint needs to be much more specific about each individual defendant's misconduct. So that's basically my thoughts. I don't really want to spend much more time on this garbage complaint because I don't believe that the attorneys who cobbled together this complaint actually spent a lot of time on this. So to summarize, the defendants, in my opinion, should evade service because the addresses that they have are wrong. Additionally, they should file a 12b6 motion if they do end up getting served, and then therefore the court has jurisdiction over them. And then in that case, the plaintiffs are then going to amend the complaint, and if they don't, then the judge is going to force them to amend the complaint to have more specific causes of action. And if they fail to do that, then I believe then this case is going to get dismissed. Additionally, I do believe that this is a frivolous case. I don't think that the plaintiffs have any shot at winning unless they're extremely aggressive in their discovery and basically turn this into a PR nightmare where it ends up hurting the reputation of the defendants to a point where they basically tap out and they want to settle this case as quickly as possible. I don't think that that's going to happen. I think that this case is either going to get dismissed or defendants are going to win outright. But I do think that there's an avenue for the plaintiffs, if they have a big budget, to be extremely aggressive when it comes to discovery and to then cause a lot of uncomfortable situations and a lot of uncomfortable hearings for the defendants. All that being said, I definitely think that this complaint needs to be amended, and if it's not, then it's going to get dismissed. And I believe that in addition to this complaint being frivolous, I also believe that it is an attack on our constitutional rights and freedom of speech, and that's another reason why I don't think that this complaint has any chance of success. So David Jaffe with beststockstrategy.com. Please leave a comment below and let me know your thoughts. Maybe you believe something differently than I do, and maybe you believe that this complaint and that plaintiffs are going to prevail in this proceeding. So let me know your thoughts below, and I appreciate your attention.